No distinction of high performance and or excellence. These regulations here today barely qualify for an acknowledgement of participation. These regulations are incomplete, incoherent, clumsy, conflicted, unrealistic, superficial, superfluous, and piecemeal. To take so long and to get it so wrong is indeed a talent which only the PNM possesses. The PNM is 6.5 years late, a special majority short, and a legitimate legislative framework for procurement is completely absent. But the PNM is rushing today 10 packages of regulations. I have identified approximately 3 hours of problems, weaknesses, and omissions. However, I have a mere 40 minutes, so here goes. Dealing with regulations out of the package record and record of proceedings. Clause 4 states, where appropriate, a record shall contain the original and a copy of the information document. I asked the PNM, where will it be inappropriate to have a record of a tender proceeding? Please let us know, where would that possibly be inappropriate? And in 4A, the approval to execute, very important. The document indicating the approval to execute the various stages of the procurement proceedings, because one must have permission, authorization to begin a procurement proceedings. So I asked the PNM, how were the pods and sheep pens in the savannah produced, tendered, and offered for the public to go and have a taste of carnival in the midst of a COVID pandemic, when the cabinet only approved a short moment after?
Mr. Deputy Speaker, the Public Procurement Act has not yet been proclaimed, and therefore these regulations are in the future, not in the present or the past.
Okay, so Senator Roberts, just again, what we're dealing with is the 10 regulations before us, and as you go along, you would call out which one that you're dealing with so that we can all follow. Continue. It's
amazing that the Minister of Finance is not aware that we are governed by the Central Tenders Board Act. We are governed by corporate governance. We are governed by financial
Vice President,
rules.
Point of order. What is before the House is a motion to approve regulations that accompany the Public Procurement Act, not the CTB or anything else.
So I've spoken to that. Senator Roberts, continue.
I'm glad to see that my honorable colleague is very energetic. But section of this document here, record of proceedings, 4A talks about the document indicating approval to execute the various stages of the procurement proceeding. So I am very eager to see this implemented so that the PNM and the Minister of Finance will understand the procedures that have existed since 1962 in the Cabinet and the approval for getting money out of the consolidated fund to begin procurement proceedings. In 4G, the reason for the cancellation of bids where the bids are cancelled. Well, this is a very interesting and very critical element, because we have seen instances where bids have been scuttled over the last 6.5 years, whether it was for procurement of ferries, when the Port Authority Board, it was stated by the Honorable Prime Minister, had not found any suitable vessels. And from a Freedom of Information application, the country learned that 11 vessels had been procured.
Point of order. This debate is not about things that have occurred outside of the regulations that we are debating.
Senator Mark, please. So, Senator Roberts,
yes.
As you continue, just as you've identified the particular regulation, just let me know, because we were in transition when I came in, which particular regulation are you on?
4G and...
No, the name of the regulation.
The name of record of proceedings.
Record of proceedings, thank you.
Mr. Vice President, please, I would like to make it clear that this is a debate and we're talking about regulations, and we must have some sort of context in what the regulation is attempting so to do. So I would ask the Honorable Minister of Finance to sit quietly and read on his lap.
Align specifically with what's before us. That's all that's being asked.
I don't know what he's so jumpy for. He's been late and now he's very active.
Go ahead, continue.
Yes. So let's move on to 4K. We see that in the proceedings, record of proceedings, the regulations here state a decision to conduct a procurement without a standstill period and the reason for the decision. Now, this is very interesting and very critical that we get this part implemented as quickly as possible, because we have seen in the recent future that government agencies such as E-Tech are awarding contracts in Tobago for construction of hotels in 17 days, and then there is no standstill period even. So the procurement period in which tenders or requests for Thank you, Madam President. The PNM clearly believes in the new concept of participation, recognition, that has taken over the world of sport, for example, in our junior classes and primary schools, where everyone who competes in a race gets a participation certificate, the same ribbon or trinket. No distinction of high performance and or excellence. These regulations here today barely qualify for an acknowledgement of participation. These regulations are incomplete, incoherent, clumsy, conflicted, unrealistic, superficial, superfluous, and piecemeal. To take so long and to get it so wrong is indeed a talent which only the PNM possesses. The PNM is 6.5 years late, a special majority short, and a legitimate legislative framework for procurement is completely absent. But the PNM is rushing today 10 packages of regulations. I have identified approximately 3 hours of problems, weaknesses, and omissions. However, I have a mere 40 minutes, so here goes. Dealing with regulations out of the package record and record of proceedings. Clause 4 states, where appropriate, a record shall contain the original and a copy of the information document. I asked the PNM, where will it be inappropriate to have a record of a tender proceeding? Please let us know, where would that possibly be inappropriate? And in 4A, the approval to execute, very important. The document indicating the approval to execute the various stages of the procurement proceedings, because one must have permission, authorization to begin a procurement proceedings. So I asked the PNM, how were the pods and sheep pens in the savannah produced, tendered, and offered for the public to go and have a taste of carnival in the midst of a COVID pandemic, when the cabinet only approved a short moment after?
Mr. Deputy Speaker, the Public Procurement Act has not yet been proclaimed, and therefore these regulations are in the future, not in the present or the past.
Okay, so Senator Roberts, just again, what we're dealing with is the 10 regulations before us, and as you go along, you would call out which one that you're dealing with so that we can all follow.
Thank you, sir.
Continue.
It's amazing that the Minister of Finance is not aware that we are governed by the Central Tenders Board Act. We are governed by corporate governance. We are governed by financial rules.
Point of order. What is before the House is a motion to approve regulations that accompany the Public Procurement Act, not the CTB or anything else.
So I've spoken to that. Senator Roberts, continue.
I'm glad to see that my honorable colleague is very energetic. But section of this document here, record of proceedings, 4A talks about the document indicating approval to execute the various stages of the procurement proceeding. So I am very eager to see this implemented so that the PNM and the Minister of Finance will understand the procedures that have existed since 1962 in the Cabinet and the approval for getting money out of the consolidated fund to begin procurement proceedings. In 4G, the reason for the cancellation of bids where the bids are cancelled. Well, this is a very interesting and very critical element because we have seen instances where bids have been scuttled over the last 6.5 years, whether it was for procurement of ferries, when the Port Authority Board, it was stated by the Honorable Prime Minister, had not found any suitable vessels. And from a Freedom of Information application, the country learned that 11 vessels had been procured.
Point of order. This debate is not about things that have occurred outside of the regulations that we are debating.
Senator Mark, please. So, Senator Roberts,
straight jacket, yes.
as you continue, just as you've identified the particular regulation, just let me know, because we were in transition when I came in, which particular regulation are you on?
4G and
No, the name of the regulation.
The name of record of proceedings.
Record of proceedings. Thank you.
Mr. Vice President, please, I would like to make it clear that this is a debate and we're talking about regulations, and we must have some sort of context in what the regulation is attempting so to do. So I would ask the Honorable Minister of Finance to sit quietly and read on his lap.
Align specifically with what's before us. That's all that's being asked.
I don't know what he's so jumpy for. He's been late and now he's very active.
Go ahead, continue.
Yes. So let's move on to 4K. We see that in the proceedings, record of proceedings, the regulations here state a decision to conduct a procurement without a standstill period and the reason for the decision. Now this is very interesting and very critical that we get this part implemented as quickly as possible, because we have seen in the recent future that government agencies such as E-Tech are awarding contracts in Tobago for construction of hotels in 17 days, and then there is no standstill period even. So the procurement period in which tenders or requests for proposals are given is very short, and it's almost bordering on unrealistic for anyone to be able, or any company to be able to become aware of an opportunity and produce a detailed architectural proposal with detailed business plan and operation in 17 days.
This is not relevant to the regulations before us.
Senator Mark, please. So, again, Senator Roberts, you're speaking to clause 4.
The period, I'm not sure what my colleague is so nervous.
It's okay. Just tighten it up a little bit, because you're talking about projects that are ongoing now and the period of time in which the project was allotted to a particular company or whatnot. Just tie it in, because I'm trying to catch on to exactly where what you're saying here is related to that.
Mr. Vice President, we are here to approve regulations to implement procurement. There must be some rationale and some reason for these criteria, these clauses, and so on. So we must give examples of good procurement, bad procurement, PNM procurement, Minister of Finance procurement, and why this section 4K, why it is important. A standstill period is very important, but it's also important to give time that is reasonable, time that is just, time that is fathomable for people to produce a bid, or else one would be, as the former senator spoke about the digital economy, that we need trust in the process. And if the process is too short, like 17 days to give a multi-$100-million proposal, it will lead the population to believe that something is untoward. And the whole idea of these regulations is to build trust in the population that the Constitution will be upheld and everyone will get a fair chance, an equitable chance at tendering for the resources of the country. We move on from 4 to 5. In the record of proceedings, it states, 1.5.1, a record shall be prepared and disclosed in a manner that avoids the disclosure of proprietary commercial information. Now, throughout the regulations, this seems to be a very important facet because one must intend that when you make a tender or a company produces documents that they should feel comfortable that their proprietary information, their bid prices and so on will remain very secret. And the legislation itself speaks to that. So we would not want, for example, if people are bidding, companies are bidding to manufacture ferries, that a governmental cabinet committee would alert another company about the lower price as occurred here in Trinidad and Tobago. So this is a very important regulation to ensure that secrecy is upheld. In section 5.3 of the record of proceedings, it says, a record shall be kept for a minimum period of 7 years following completion of termination of the contract. While this may seem a good time limit, especially based on civil proceedings with a 4-year stipulation, I will suggest that politically and for criminal proceedings, and since it's going to be kept on a digital record, that the records be kept in perpetuity forever in case we find out later, decades later, that something may have been untoward and a criminal proceeding would not have a time limit. So I would suggest that these records be kept digitally so that if we find out about gravel rolling from by a hospital to by another project and it's 20 years later, that the police can still get to the information. So I disagree with the records being eliminated for no purpose. We move on to, trying to move quickly, I can't get through all 10, challenge proceedings, Mr. Vice President. Follow me carefully. I expect some squats to be going on over there shortly. Challenge proceedings, section 2.3, the application for review, it states, the decision of the office shall be binding on the supplier or contractor. However, in the Parent Act and in other areas, we can see that anyone can apply for, if they believe or they see or they have information that a tender process was not done in accordance with these regulations, a citizen, the public, the media could have applied. But in this case here, it has been narrowed down to only the supplier and or contractor. And we would like to know why has that been done. Because you would understand that sometimes in Trinidad and Tobago, a very small society, some suppliers and contractors, even if they felt hard done by, they would not want to willingly come up against the government who is in control of the coffers and future tender proceedings. So they would fear victimization and they may be afraid to come forward. Whereas a media reporter, a whistleblower, or someone else would, if they are given the information and they are not afraid of the government, would be able to come forward. So I think that it is required that this be widened to include other groups or other individuals who can report in order that we get to the truth. As you may know, in Trinidad and Tobago, some instances in financial tenders under the Ministry of Finance, certain small companies have just miraculously started to beat major banks who've been in existence for 40 or 50 years with a wide asset base, with the ability to make smaller interest payment bids and so on. But the smaller companies have been winning luckily over the last 6 years. Now, why have these big banks not complained? because the government, any government, controls tender after tender. And in Trinidad and Tobago, the history has been that when you complain, somehow you do not win any more tenders. So it is a very serious point that victimization needs to be covered in these regulations so that people can get a fair shake, that reports can be made without any fear or favor. Section 4C of the challenge proceedings states, the supplier or contractor who made the review application has not demonstrated sufficient standing by way of either a pecuniary or otherwise economic interest in the procurement proceedings. Again, this is limiting the person or the group who can make an application to someone who has suffered actual loss. In many instances and in other portfolios that I have held over the time, many of us receive information and the companies or those who are involved are not willing to go forward to make the complaint for fear of victimization in other areas. So it is clear that we need to open this section up so that other individuals can report on behalf of contractors who may have been, or suppliers who may have been disadvantaged, so that we can get to the truth and everyone, there can be equity across the board. In 5.2, it states, a member of the office who has a direct or indirect personal interest in a matter being considered or to be considered shall, as soon as reasonably practicable, after the relevant facts concerning the matter have come to his attention or knowledge, disclose the nature of his interest to the office, which shall appoint an alternative member. I think everybody on that side in the government should read clause 5.2, especially those who have been recusing themselves from the cabinet for 210 times, because this will show that it is not only good enough to step out of a cabinet room and have a coffee, but that there needs to be a replacement, because the influence still exists if you are around the meeting or around the process. So we need to implement this regulation very quickly, because the PNM seems to only understand procurement right here in the Senate today, but not for the last 6.5 years. They have gone recusal after recusal, stepping out and not understanding conflict of interest, but coming here to feign that they want to provide us, the country, with a stable, fair, equitable procurement regime. Challenge proceedings continuing, moving to 8.5. 8.5 states, notify the procuring entity against whom the review application is made in writing and delivered to attention of the procurement officer, and continuing, pursuant to section 61(2) of the Act, and the review application shall include with notice a complete copy of the application. Now this leaves me baffled. You are stating here that upon recording the receipt of a review application, the office shall notify the procuring entity against whom the review application is made in writing and delivered to the attention of the procurement officer. Why would you want to inform someone who is coming to be investigated, hey, this is an investigation, someone has put something, a report in, and there is something that has been gone wrong? What you have just done is alerted them, given them time to correct, backdate, or play any games that they want to clear up the procedure or to make the investigation even harder to get through. And this needs to change, and it must be if the procurement office sees that there is reason to move forward, that it takes a similar vein to a warrant as in the court, and it's immediate, because all of the records as stated here should be digital, all of the documents should be on a form, all should be easily accessible, and therefore, as long as the procurement regulator or the office believes that something is untoward, there must be no time gap to allow anyone who may have nefarious motives opportunity to cover up, hide evidence, or delay documents. So I would suggest that this power be more immediate. Once they have determined that a process is flawed, they must move in and seize all files immediately. There is to be no time lag, no time to change. Section 9 says, pursuant to Section 55 of the Act, the procuring entity against whom the review application is made shall within 3 working days. Okay, again, 3 working days. Some people may feel that's a short time, but when you have people who are doing or trying to fix a process or scuttle a tender or show preference, 3 days is a long time for them to get backdated information, backdate transfer information on Porsches that were sold, get things out, change up the facts as they occurred. These things could happen at any time without anyone noticing. So we need to watch that very carefully, and I hope the government, especially legal attorneys, luminaries, will understand the point that I'm making. 9.4, the office may, if it is satisfied that the review application was duly served on the procuring entity against whom the application review is made, and the procuring entity failed to submit a written reply without good cause, proceed with its deliberations on the basis of evidence before it. As such proceedings, anybody who has studied basic law will know that you're going to have problems with that. This clause goes against the Constitution. It goes against the rights of natural justice. It goes against all the principles of law in which a person is allowed to face their accuser and defend themselves, and this will lead to a lot of litigation and the government and the taxpayers paying money to contractors or suppliers who were unjustifiably ruled against without being given an opportunity to defend themselves. The lawyers will deal with that more. Section 9.5, a procuring entity may at the time of submitting its written reply request that the office authorize it to award a procurement contract or enter into a framework agreement on the grounds that a delay. This is absolutely not on. We are saying that something is wrong. We've gone through a process and we find the tender process has not been adhered to. And then we are saying we are allowing the procuring entity to continue along a contractual procedure with letter of intent and contract, thereby making it further even more grievous when you delay or you stop or you scuttle or you determine that the award was wrong. You are opening up the country and the government to greater awards of damages. You are giving the contractor or the supplier who may have won the flawed tender process greater legal arguments to go to the High Court, to approach the court, to state that they have been done wrong and they deserve damages. So I think that is a lacuna that needs to be addressed by the legal entities on the government, please. 12.2. In determining the order and time of the hearing, the office shall give sufficient consideration to preventing the delay of the proceedings. That is vague, vacuous, and allows for lawyers to find loopholes, to delay, to carry you on for years. And this is a tender process, and tendering and contracts and suppliers, every day will be money. So that needs to be tightened up. I'm not sure the government understood what they were trying to do there. And in 13.2, where a party, despite having received notice of the hearing, fails to appear at the office, if satisfied that the notification was received, all of this goes against the case law. All of this, the law and the High Court judges are not going to accept. You can see that these will be struck down. So please change those, link all of these regulations strictly and firmly to the Constitution, make good law so that we will not end up in court and the taxpayers have to pay money, millions of dollars after dollars. 13.8. Notwithstanding the procedures set out in this regulation, the office may proceed to determine a matter before without a hearing if it is satisfied that the information in the form of documentary evidence or case files presented is sufficient to make a decision on the matter and any decision made. Same thing here. This is unconstitutional, and it's giving powers to this office of the procurement regulator over and above those of a high court judge, the appellate court. And it's just not on that they can determine that they received information without giving anybody an opportunity to be heard, that they find that it's enough to withdraw an opportunity and money from material earnings from a citizen based on what? On their human frailty, on their determination. This will not stand up in a court of law. 14.2, subsequent documentary evidence shall be admitted only where, in the opinion of the office, it is relevant and only the office's consent. This, again, it appears that whoever was designing these regulations isn't sure what they want to do. They want to be firm and then they want to be soft. They want to move fast and then they want to delay. If you state that all of in the Parent Act and in the previous regulations that all the documents will be in and a tender process, there are no documents that are left and right on a bottom shelf and a drawer. They're in a form, you've set out the form, you've paid the price, you've conducted your procurement properly. All documents should be available that are necessary for any analysis of the procurement procedure. And therefore, to put this clause in is nuanced, it's unnecessary, and it makes the regulations look as if we're unsure what we're doing. Because what you're saying at one time, that you get your documents, you have 3 days, which is too long. Then if you feel, or if the procurement regulator, the office feels that something else that you may have, where you got it from, how long you got it from, where you found it, where was it hiding, that they could bring that in to add to evidence. It makes the process very opaque. It makes it cloudy. Moving on, retention of public property. We are going to, oh my goodness, 4.1, retention of public property. A public body shall ensure that it protects and maintains the public property with which it is entrusted in a manner designed to maximize the use of, and where applicable, preserve or enhance the value of the public property. Well, it's amazing that this even needs to be written in laws and be debated in the Senate. So we are saying that we need regulations to ensure that a public entity will keep assets belonging to the people in a pristine state. Now we have seen, and there are many examples, especially in the last 6.5 years, that this is not occurring. So while I may find it quite obvious, clearly the government needs these regulations to be passed to take care of Guaracara Park, Palo Seco, Point-a-Pear Refinery, all the houses there that are deteriorating daily, the Port Authority, and we are seeing even Trin-City Mall that has lost about 60% of its clientele is now up for sale. But if you lose 60% of your clients, then your price is going to be less. And if you deteriorate, you allow assets to deteriorate, like Guaracara Park, which is now fit just to feed goat and sheep. Maybe the Minister of Agriculture will be happy. We could build some pods for a taste of carnival in Guaracara Park. But a public body shall adopt a risk-based, says 4.2, a public body shall adopt a risk-based approach to the retention of public property in order to achieve the principles of good governance, namely accountability, transparency, integrity, and for money. Then section 3, 4, and 5. This is one example. These regulations are a clear, definitive position why the PNM must go, because all of these regulations are not being adhered to right now. They have not been adhered to. And if a government requires this piece of paper here, regulations 4, 2, 3, 4, 5, and 6, in order to ensure that the people's assets are maintained, then the government must go. They are incompetent and they've allowed our assets to diminish in value and the people are suffering. In 5.1, a public body shall establish a written policy that highlights its objectives for the retention of tangible and intangible public property in accordance with the I think we should take this set of clauses here and just stick it on the Balize house that is going up in the sky, the $120 million edifice. We should do some procurement on that. Where did the money come from? We're moving on to 5.8 of retention of public property. A public body shall perform a physical stock count for comparison against its inventory record on an annual basis or shorter intervals when necessary to achieve the principles of accountability, integrity, and value for money. 6.1. A public body shall be responsible for the disposal of its stores and equipment which are deemed unserviceable, obsolete, or surplus. Well, this is a very critical element because people who determine that certain equipment is obsolete, their friends, financiers, and family could get it for very cheap. We are seeing, and we've seen videos by Mr. Victor Roberts, a citizen from Labre, of our assets being removed from all over the Southwest land, whether they were pumping jacks with a big expensive equipment being moved, and we don't know who is in charge, no security, no assets, no board, no people in charge. We don't know where they have gone, what has happened, and it is rather amazing that the PNM, who is overseeing the decimation of the people's assets for 6.5 years, now comes to bring regulations that they have not and cannot uphold. 6.3, where a public body decides to utilize a public sale or tendering or public auction and the net book value, market value, or residual value of the stores or equipment is in excess of the $100,000, the public body shall publish in at least 2 newspapers and so on the tender. But we are seeing that even buying scrap iron and old battery, buying the PNM has not done a fair tender process. We see the scrap iron industry complaining that a shell company that only was created months before and was allowed to bid and purchase assets belonging to the people of Trinidad and Tobago under Heritage Petroleum. And we see no movement from the Minister of Finance to audit that, but he comes knowing full well that these are the regulations that should apply to good procurement. So the PNM believes that brilliant procurement, fairness, equity, and no corruption will begin in March. But from September 2015 to February 2022 is old mass in pods. We move on now. Pre-qualification and pre-selection. Section 29(1) of the Act, it talks about, and I won't go into the Parent Act as read, the President said she did not want too much, didn't want Senator Mark going into reading the Parent Act, but we'll move to 8, Section 8 of this pre-qualification and pre-selection. In response to the invitation to pre-qualify, suppliers and contractors shall register in the procurement depositories database and upload the required information and supporting documents to enable the public body to determine whether or not it meets the criteria for pre-qualification. Well, this we will have to ask the PNM government. Why, when we are down in Blanchy Shares, which is not spelled as the Attorney General spells it, and we see a slow boat moving towards Tobago called the Cabo Star, how did they qualify to tender? What were their finances? How are they qualified to earn $200 million and counting as this government wastes taxpayers' money on a boat that has been described by the Honorable Prime Minister as crooked? Yet it continues day in, day out, and we come here to debate regulations which state that companies should present certain qualifications in order to bid. Yet everything this PNM government has done has brought about companies fly-by-night who should not have bid, could not have bid, scuttle. If there were red flags on Facebook, the PNM chose their colors correctly, because everything about corruption, everything about bad procurement is red flagged by the People's National Movement and this government. ineligibility proceedings. And weighted evaluation. Well, let me go to ineligibility proceedings first. 9.2. It makes absolutely no sense because you're being deemed ineligible. Let us read 9.2 of these regulations produced by the Honorable Minister of Finance. Notwithstanding the ineligibility of a supplier or a contractor, a procuring entity may continue contracts or subcontracts in existence at the time of listing. Well, I'm sorry for laughing. So we determine that a contractor or supplier is ineligible. We go through a scrutiny and so on. And we say, well, even though you are ineligible, if you all happen to scrape by before we notice, any contract that you are currently doing continues, even though we have determined that you're ineligible. So that's like saying you test positive for steroids, but don't mind that. You tested positive today, but you had a medal and a competition and a record that you got last week. We leave you with that and we won't take it away. Even in competitions now, once you are seen to have been caught cheating, then you are ineligible and your medals are withdrawn.
Senator, you have 5 more minutes.
How is it possible to state that a company is ineligible to do service, to provide service, to work for the government now, but if they had a contract before, that the entity can continue to live up to that contract? I think 9.2 must be deleted, withdrawn, and pretend that it was never penned by an intelligent human being and brought here to the Senate to be debated. I will now go back a little bit. Weighted evaluation criteria is very serious. In 12A and C, when you think about the scuttling of tender procedures, these are very serious matters. And you must give reasons why tender proceedings have been scuttled. In Trinidad and Tobago, we have seen that tenders were scuttled and information came back that the information given to the public was not true. And we created, under the PNM, the new tender procedure of ministers procuring Galleon's Passage, a fast boat to be leased. Galleon's Passage, a slow boat to Toco, was purchased for 120 million by ministers of the cabinet. And when they realized that it was slow, they said, no, we bought it for a port in Toco yet to be built. Procurement legislation is very critical. It is very serious. The PNM has dilly-dallied since 2007. White paper, green paper. They waited for Calder Hart and Ken Julian to comment on it then. The People's Partnership brought legislation with a special majority and was moving forward. The PNM came into power on Emailgate and then crashed procurement legislation. So, Senator, they brought it here.
Senator Roberts, at this point you've gone, of course, you were going along with each particular regulation and tying it into the particular clauses to which you were speaking to. Now you're veering off completely in relation to relevance and the regulations that are here. So I'm going to ask you to come back, if you're still doing the regulations, please come back to what's before us.
Mr. Vice President, all 10 packages of regulations deal with procurement. They deal with proper expenditure and fairness and equity in the society. They deal with things that this PNM government does not understand because they have recused themselves in the cabinet 210 times. They do not understand fairness and equity. They do not believe in merit as they quash a police service commission and a merit list. This regulations is about merit, giving every citizen of Trinidad and Tobago an opportunity to take part in the development of national pride in our society, the development of the infrastructure in this country. To have gutted procurement legislation, come to the Parliament and the Senate, and now bring regulations that make no sense, are rushed, and do not identify tackle and produce a framework from which we can be trusting, where the population can believe that when they tender, they have a fair chance and we'll get value for money, propriety, transparency, and accountability. These regulations are woeful. And I suggest that the Minister of Finance, even though he has taken an inordinate amount of time to produce nothing, that he go back to the drawing board and bring something that we can all be proud of to ensure that we keep our treasury safe from the PNM. Thank you, Mr. Vice President.